Well, I just want to make sure for the simple fact that the last time.
I'm talking to you.
Oh.
No taping in the
No,
court.
taping, even though all courts, according to the U.S. Constitution, are supposed to be open courts.
Officers,
Yes, Your Honor.
they're taping in the court.
Officers, you should arrest the judge because he's not violating the Constitution nor the Oklahoma Constitution. He under Article 2. All I'm saying is that follow your oath of office under the Constitution. That's all I'm saying, gentlemen. Just follow your Constitution. Follow your oath of office. We're respectfully requesting.
This is your before this court. No taping in the court. Now we'll proceed. Sir, I'm talking to Mr. Ecenarro. Counsel, distinguished attorney. This is a motion before this court. Father Allenstein, court wants to let us in, Ecenarro know that this is not a litigation of case. We're here for a hearing concerning an out-of-time appeal. That's the only thing that this court would consider today.
So let me start off by saying that at the first hearing, the judge failed to give me a court of record and put it on the record. So I can't use any of the documents, which I have been able to consult with the House of Representatives and the senators, in which they have within their jurisdiction to investigate the judicial branch, including you, Judge. Apparently, you failed to give me a court of record, a transcriptionist. The reason why you did that is to railroad me, but at the same time practicing off the bench. This is why we're here today, because you have failed on the first occasion to give me a court of record, a transcriptionist. So I'm going to transcribe what was said, what you stated, what the officer stated, what Mr. Ecenarro said, the living man, as a sui juris, and also the district attorney. Not once did you provide that. Now, Mr. Ecenarro put that in his affidavit, in which he filed on citation number 18-5056-8390, which you failed. The only reason why you keep this monopoly going and this corruption going within this courtroom is for the simple fact that you don't want the Supreme Court or anybody to hear what's really happening in these courtrooms. And this is why I brought witnesses. This is why you failed to record anything. Because you don't want the people to know, the people of Oklahoma, how bad you're taking advantage of them and how you are failing your constitution, your oath to the Constitution, the Oklahoma Constitution and the federal Constitution, including, let me say, 2014 Oklahoma Statute Title 11, City and States. That's 1134-106. Use of unmarked vehicles prohibited. Officials' uniform required. The Statute of Oklahoma hereby declares that the state that increased numbers of persons impersonating law enforcement officers by using routine traffic stops while using unmarked cars is a threat to the public health and safety of all citizens of the state of Oklahoma. Not just you, not just your family, but the people of Oklahoma, including me. Therefore, it shall be unlawful for any municipal police department to use any vehicle which is not clearly marked as a law enforcement vehicle for routine traffic enforcement, except as provided in Section 12218 of Title 47 of the Oklahoma statutes. This is why you didn't want a transcriptionist. This is why you prevented me to go take this to the appeal courts, because there's nothing on the record in which the district attorney holds almost all these documents for a month and a half in their office, in which I went down there and I have witnesses that validated I came in. This is what you want to do, and you don't want the public to know. Because at the end of the day, under Crest, you have a financial gain. And that's a fact. And I can prove it.
You finished?
Oh, I'm done.
All right. That means no more commentary from this particular defendant. The defendant notified this court that he's done. Counsel.
Judge, it appears that we're here on the defendant's application to appeal this out of time. I wasn't the initial prosecutor on the case, but in reviewing the notes, this matter was set for trial back on February 27th of this year, 2019. The issues of jurisdiction, all that was resolved during that time. The defendant was found guilty. He sought to appeal this on 3/18, which the Court of Criminal Appeals has made very clear in Chapter 18.
Okay, counsel, before you continue, they wanted to take that. I want them to get that on tape if they wanted to take what you're saying, okay? You want to take it, go ahead.
Can we take both sides or just one side?
Well, are you going to repeat what you
Absolutely. So let's take both sides.
Go ahead.
Okay, good, thank you.
Well, we already taped it, so we have to go through it again.
Okay.
Now, all right, we'll get her side.
As I was saying, Judge, the Court of Criminal Appeals has made very clear in Chapter 18, Rule 2.5, within 10 days from the date of the judgment and sentence is imposed in open court, the defendant must file with the trial court clerk a notice of intent to appeal and designation of record in the form prescribed. Obviously, he didn't have a record at that time, so that issue would be moot. Nevertheless, according to the Oklahoma Court of Criminal Appeals, his appeal would have had to have been filed on 3/7. It was filed on 3/18, which made it out of time. The defendant then turned around and filed this application to file an out-of-time appeal on 3/21. Judge of the Court of Criminal Appeals also addressed this. The first thing I like to point out that this is improper. The defendant filed it on a motion to set aside bond forfeiture warrant form. The Court of Criminal Appeals has made very clear in Chapter 18 as well, Rule 2.1, that any out-of-time appeal must be filed. The proper procedure is to file an application for post-conviction relief, which the defendant did not do. So on that grounds alone, Judge, I would ask you to overrule his motion. Moving further, the Court of Criminal Appeals also says that a key component to being granted an out-of-time appeal is that the defendant has to prove that he or she was denied an appeal through no fault of his own. Judge, absent this defendant having proof that the court clerks refused to allow him to file his appeal with us, after him having proof that the judge refused to allow him to file his appeal, it is through his own fault. As such, Judge, he is out of time and actually denied his relief for an out-of-time appeal.
So everybody's finished presenting their evidence before this court.
Well, I gotta say one more thing, if that's okay with you. And I appreciate the latitude. She wasn't there. That's number one. She wasn't there when the court transcriptionist was not there. She was not there when the court when you asked for a court transcriptionist. And number four, you cannot appeal without having your transcripts, which she knows and you know. So at the end of the day, this is either a kangaroo court or not, because if I under the Fourth and Seventh Amendment, I have a right to a jury trial in which you refused. And this explains why we don't have a court transcriptionist, which she wasn't there. And she should know that I have the right to, under the Fourth and Seventh Amendment of the Bill of Rights, a constitutional right to a court of record or a jury by trial, in which you denied. So she wasn't there when you said no. She wasn't there when you were violating my Bill of Rights, my constitutional rights. So how easily can she sit there and make those comments? When you refuse to have a transcriptionist to transcribe everything that was said. How convenient. That's all I got to say.
You have nothing more to say, so I'll start with mine. Number one, with no interruptions, you put this on tape. There's no jury trial on traffic cases, Sixth Amendment. Number two, this court stated twice during the trial on how a record can be guarded. It stated personally at the beginning of the trial, and second, he stated personally to this defendant when he approached the court. Number two, we are not here to relitigate the case. Number three, the defendant cites in his motion, Title 11, Section 34-106. The defendant presents to this court an exhibit apparently taken from the internet named Justicia, Justia, which furthermore, under his exhibit, page 6, number 8, it says 2014 Oklahoma statutes, Title 11, City and Town, 1134-106. Use of unmarked vehicles prohibited. Official uniform required. The court would like to inform this defendant that wherever he got this from, that's not in the statute. The statute says under a Title 11, 34-106, it does not say use of unmarked vehicles prohibited, official uniform required. What the statute does say is using unmarked police cars for routine traffic stops. The court would read that statute. The state of Oklahoma hereby declares and states that the increased number of persons impersonating law enforcement officers by making routine traffic stops while using unmarked cars is a threat to public health and safety of all the citizens of the state of Oklahoma. Therefore, it shall be unlawful for any municipal police department to use any vehicle which is not clearly marked as a law enforcement vehicle for routine traffic enforcement. Now, it appears to this court that the defendant conveniently leaves out the exceptions. Now, the court will get to the exceptions, except as provided in section 12/2008, strike that, section 12-218 of Title 47 of the Oklahoma statutes. In addition, section 12-218 of Title 47 of the Oklahoma statutes, a peace officer operating the law enforcement traffic stop shall be dressed in a uniform, which he was on that day, including shoulder patches, badge, and any other identifying insignias normally used for employing law enforcement agency. Somehow that was completely left out. Furthermore, the exhibits even presented to this court show that the qualifications of an unmarked vehicle. Section 12-218 of Title 11. Strike that. Title 47 states, a law enforcement vehicle, when used as an authorized, strike that. An unmarked.
Excuse me, Your Honor. It seems like you're practicing off the bench because apparently you're striking and going.
So I haven't interrupted you. Now you're interrupting the court. I'm not going to read the whole statute to you, sir. I'm reading parts that's
right, I have it right
I'm
here.
reading parts that's pertinent to this case. This court has been very patient with you. It allowed you to express yourself. The court asked 2 times. Were you through? You stated to this court you was through.
But at the same time,
and now I'm making my decision up here, and you're interrupting me.
true. I just didn't know you were practicing from the bench. But go ahead. Go
I'm
ahead. Go
reading
ahead.
the statute, sir.
Right. I didn't know you were practicing from the bench. So go ahead.
You already said it 2 times.
Yeah, you're right.
Thank you. I heard you the first time.
Okay.
An unmarked vehicle used as a law enforcement vehicle for routine traffic enforcement shall be equipped with the following combination of lights: 3 flashing red, blue, or a combination of red, blue lights emitting the flashing lights to the front of the vehicle. 2 flashing white light emitting the flashing white lights to the front of the vehicle. 3 flashing red, blue, white, or any combination of red, blue, or white lights placed at and emitting the flashing lights from the 4 corners of the vehicle so that they are visible from 360 degrees. And 4, 1 flashing red, blue, amber, or a combination thereof of red, blue, or amber emitting the flashing light to the rear of the vehicle. Now, the exhibits presented before this court by the defendant, I might say, depicted the unmarked car with the lights that was clearly visible to this particular court. Furthermore, on retroactive performance now for then is also before this court today. The defendant requests this court to grant his motion to out-of-town appeal. Then, the avenue for seeking such relief is controlled by Rule 2.1E1 of the Rules of the Oklahoma Court of Criminal Appeals, Title 22, Chapter 18, Act 217. Strike that, 2017. The appellate court's rule is particularly clear and succinct. It states, a petitioner's right to appeal is dependent upon the ability for he or she to prove, strike that, what ability to prove he, she was denied an appeal through no fault of his or her own. The emphasis is added. See Blades v. State 2005 OKCR 107P3D 607. See also Smith versus State 1980 OKCR 43 611P2D 276. Court of Criminal Appeals rules, not this court's rules, the Court of Criminal Appeals rules. Commencement of an appeal, 2.1B. An appeal is commenced by the trial counsel's filing with the trial court a written notice of intent to appeal and a designation of record as prescribed by Rule 1.14C within 10 days from that particular date. Now, it was expressed before this court that the trial was on February 27, 2019. The appeal bond was set. Keep in mind that this court notified the defendant not once, but twice on how to appeal. The defendant filed a motion, it appears, to try to perfect his appeal on 3/21, it seems like, 19, and thus brings us to this particular hearing here today. Again, the Court of Criminal Appeals is very clear and succinct in the rules. Again, this court make note that it's not this court's rules, it's the Court of Criminal Appeals rules. The 10 days is far surpassed that particular time. Also, appeal out of time under Rule 2.1E, general procedures for obtaining an out-of-time appeal. If the petitioner seeks an appeal out of time, the proper procedures to file is application of post-conviction relief, requesting an appeal out of time. And that wasn't done in this case. Also see Blades v. State 205 OKCR 107P3D 607. See also Smith 1980 OKCR 43 611P2D. The motion before this court. This court would like to inform the defendant that has been very patient. The court took its time to read the applicable statutes pertaining to the trial that he had. Also, the court want to inform the defendant that he left out the exception to the particular statutes that he was examining before this court. Also, the information that he provided to this court is not the statute. It leaves out a crucial part of this statute. This court has been very patient. Again, the out-of-time appeal was not not granted according to the rules of the Court of Criminal Appeals 2.1B as well as 2.1E. Defendant can appeal the appeal bond. I believe it was set at $200. He can appeal to the Court of Criminal Appeals and go from there. On 4/30/2019. The motion is denied out of time. Non-pro tunc. Parties may be excused.
You forgot a couple things, but that's okay. So let's do a live stream out here.